Thank you, everyone. Please be seated. All right, our final oral argument this morning is Baldwin versus City of Estherville. Mr. Bjornstad, you may proceed.
May it please the court, counsel. Thank you very much for having me here. There is agreement in part of this, and that is that officers are somebody that everybody expects as you're going through your life here in Iowa. We all expect that they should know the law. They should, at a bare minimum, know the laws that they are duty-bound to enforce. In this case, we also agree that there were 14 chapters of the Iowa Code, not sections, but chapters, that these officers mistakenly thought were in their ordinance book, and they weren't. And this is how Greg Baldwin gets into the jail, on an imaginary law that doesn't exist. And so on that thing that we all agree on, that the officers ought to know the law, everyone agrees. Judge Bennett calls it sloppy study of the laws. The defendant's first defense was, under federal law, negligence. They tried to point out that what they had done was read in these 14 chapters, and that was a negligent mistake, and their effort there was to prove, well, it wasn't a constitutional violation, it was just negligence. That was the first thing that they came in and admitted. Now, keep in mind, that type of mistake encompasses 321J. This defense asks everyone to believe that these officers thought they could write violations of E321J, a city ordinance. I very much doubt that that is the case, but even if you believe
Here's
it,
one problem I have, kind of. You know, you're sort of arguing the merits of a summary judgment motion, and Judge Bennett kind of handed over the case to us and said, rule on the summary judgment motion.
He sure did.
And that's really unusual to my mind for a certified question. I've been at this 8 years now, and I've seen certified questions, but I've never had where the court just says, please rule on the summary judgment motion.
well, he's safe in academia now.
Well, yeah, he is, but I see him now and then, and I may get a chance to ask him about this when it's all done. But anyhow, normally we rule on questions of law, and if the federal district court is so excited that it really wants an Iowa state court to rule on this case because it involves Iowa issues of law, one option it could do is decline supplemental jurisdiction at that point and send the remaining claims, which I understand are only state law, to the state court. But isn't it unusual for us to be kind of deciding a summary judgment motion on a certified question?
Well, I think, and I don't want to speak for Judge Bennett, and I obviously can't speak for this court, but I think what he'd say, or what he told me anyway, was that because the facts aren't disputed here, I think he searched and searched and couldn't really find disputed facts. Nobody disputes what happened or that.
But following up on Justice Mansfield's, I mean, he has 6 certified questions, and 1 is a question of law, 3, 4, and 5, and maybe the last one is a question of law. But number 2 isn't. He wants us to decide the summary judgment, and we have a case, Corrado, that says we don't do that. We don't, a certified question is only we find questions involved as a matter of law. And so, I mean, if we answer 1, 3, 4, 5, and 6, I mean, don't we have to send it back for them to determine whether or not those legal issues lead to a summary judgment or not? Because we don't search the whole record when we do a certified question. We only base it on the facts he put in the certified record. And surely those aren't enough to do anything because we don't know all the other facts involved in this thing.
They might be. They might be. The only reason I say that, and I think it is an unusual case, but because both parties have moved for summary judgment, and there is a bit of a agreement that the facts are not very disputed.
Summary judgment is basically sort of a mixed question of law and fact. The fact question being, are there any undisputed facts? And how do we decide that based on what he told us?
Well, to be candid, I'm the one who asked Judge Bennett and said, I think this is a jury question and not necessarily a question.
It may
for the
not be a
court.
jury question, but someone's gonna have to decide whether the facts are undisputed or not. And no one certified to us they're undisputed.
I don't know of any dispute myself, and my recollection is that Judge Bennett pointed out to me specifically that they were undisputed. But that's an interesting procedural question on that, question of fact to the extent there is any.
Once you
'Cause
get to,
we've decided not to answer a certified question of Judge Bennett in the past when he sort of did that. And that was in the Corrado case.
how about the questions of law here? But it seems to me there's several. One is whether the city can assert a qualified immunity defense. The majority in Baldwin had I'll call it the due care defense. And the question then becomes, can the city assert it? And Manel and Owen are some of the cases that I discussed in my Baldwin dissent, but what's your best argument that the city shouldn't have the qualified defense if the individuals have a due care defense?
And if I'm not, I want to answer this very directly, but it's bringing to mind a fascinating question that Justice Wiggins asked in the Venkus case. And that was about 670, I think, .4, and the statutory immunity. And so I promise I'm getting there. It's just I have, that sparked some things that I hope to talk about. The question was, doesn't 670.4 provide all due care, and so, doesn't the city automatically have the defense? And the first thing, and I've got about, I lost track, there's so many, it really did spark me thinking this morning. The first is that just about a month ago, I was over at the legislature, and they called me and Dave O'Brien down there to speak because they're amending the Municipal Tort Claims Act and the Iowa Tort Claims Act. They had a bill that wanted to amend it, and you wouldn't have believed this thing. They were redefining what an arrest is. They, different from seizure and under the Constitution, they were, or the statutory definition either. It was even more stringent. They would have, that bill in its form would have just eviscerated Godfrey actions under Article 1, Section 8. So the question is, why shouldn't the legislature, or I'm sorry, why shouldn't the city get it? Well, under 670.4 anyway, because of the nature of the action, you wouldn't want the legislature to just say, hey, absolute immunity is what we're going to have. We're going to basically abolish Godfrey claims.
Yeah, but you brought a constitutional tort, which is covered by 670. I mean, the definition of a tort includes a constitutional tort. And if I'm wrong on something, tell me, will you? And the other problem becomes, it says, any claim based upon an actor, this is an exempt claim, which sounds to me like the immunity we gave the employees in Baldwin, which I don't know why we did that, but we did anyway. Any claim based upon an act or admission of an officer or employee of the municipality exercising due care in the execution of a statute, ordinance, or regulation. And they were executing an arrest, which is statutory. They were getting a warrant, which is statutory. So it seems to me that we don't have to go through this old common law and whether the immunities were vicarious liable or not, because the Municipal Tort Claim Act gives the due care exception already. And it's actually consistent with Baldwin. So why are we even asking that question when it's pretty clear the statute provides it?
Because of the nature of the right, I think that the legislature shouldn't be left with that sort of control over Godfrey actions. If they do, then that danger becomes possible absolute immunity that they could write right into the law.
Well, they could take away all sovereign immunity and say you can never sue a municipality.
Well, but the right of, when you're talking a constitutional action, the legislature shouldn't be in charge of that. These are the protections for the people. This is the one area where the legislature shouldn't come in and say, no, we're chopping this off. Otherwise, we're just the minority, and I've been in the minority my whole life, but the minority then is subject to the whims of the majority.
Is it your
of the
contention that the legislature can't at all regulate Godfrey claims?
I don't know, and like I said, I've been thinking this through this morning. I think that those are very interesting questions about notice and maybe slighter regulations. But once you open that door to the legislature coming in and writing up defenses or
Well, they could
making
reasonably,
themselves immune,
surely they could, if they wanted to set up a statutory framework for Godfrey-type claims that provided for notice and a method of processing the claims, and maybe a statute of limitations, as long as the statute of limitations wasn't 2 hours. A reasonable statute of limitation, a reasonable procedural framework. Surely they could do that. That's a different question than immunity, I take it.
that's a different question than immunity, and maybe they already have done that with.
Getting back to this question about whether the all due care immunity applies to the city, I guess on that one, I agree with Judge Bennett. I thought we decided that in Baldwin. The question was, can a defendant? And we answered the question. And it would seem to make very little sense to have an immunity that would apply to the individuals, but then would just, for the very same conduct on respondeat superior, allow you to sue the city.
Well, a couple of things, and I'll list them real quick so I don't get lost. But one of them is the historical common law, and that's the base of the all due care defense. And under the historical common law, municipalities did not have that type of immunity. The second thing is then if you look at the actual intent of Chapter 670, it's to allow liability. It's to make municipalities subject to liability. And so for those two reasons, I hope I'm answering your question.
I hate to go back to this, but you pled this as a 670 claim.
I did.
Yeah, so, you yourself said you're subject to 670, and if we jump ahead, 670 exempts punitive damages, that you can't get punitive damages on a 670 claim, and you can't get attorney fees on a 670 claim.
670 does a lot of things. The Iowa Tort Claims Act did a lot of things as far as, they wrote right in there, you've got to have, the 6-month notice? And I'm sorry, I forget the case, where you've got to give the notice within 6 months, and then this court said no. That's not something that can be controlled by the legislature, because it puts everybody in different spots as far as civil plaintiffs.
But 669, the State Torts Claim Act, doesn't include constitutional torts and has different exemptions. They're not similar laws.
Agreed.
I should say they're similar, but not the same.
Agreed. I think I did bring it as a action under Chapter 670. I don't think 670 can be used to limit people's rights. I think that if they would like
You
to
want us to
expand
strike
rights,
part of 670? Are you saying, for example, as I read 670, maybe I've got it wrong, but punitive damages are not available against the city, might be against an officer. But let's just put it this way, to the extent there's a limitation of punitive damages in 670, you're saying that can't be enforced, I take it.
because of the historical nature and they're a particularly effective remedy with a constitutional violation, punitive damages. And so these questions haven't been decided. They were available here in Iowa for individual defendants for 100 years or better.
Why do you need punitive damages?
In this case, and it's in the brief, and I cited that Webster v. City of Houston, this decision or this issue is undecided. In this case, if there are no punitive damages, You're dealing with decisions made by the police chief, a police captain. I mean, they've got their stamp of the city on this. So what that means is if these officers are never going to be corrected by anybody, their supervisors are in on it. The punitive damages are to correct people from doing things that are wrong. These officers won't face anything. Second, the electorate will never probably know that their own officers, police captain and chief, think that 14 chapters of the Iowa Code are in their ordinance book and are picking people up and putting them in jail on that. Those are two considerations for punitive damages against a city in this case. Oh, I'm sorry, I must be way over.
You may sum up.
I don't have much to sum up. To the extent you're able, I hope you grant summary judgment, and thank you very much again for having me.
May it please the court. Mr. Bjornstad, counsel. My name is Doug Phillips, and I represent the city of Estherville. There has been some discussion about the nature of some of the questions that Judge Bennett certified. I will tell you that I politely resisted some of the questions that seemed to ask this court to find facts, and Judge Bennett told me I was wrong. And so we have these 6 questions, the 6th of which has to do with whether, should you decide that either punitive damages or attorney fees, or both, are available in this constitutional tort case, would that decision be retroactive and apply to the trial of this case and other pending cases? This court employs a 3-factor test in determining whether or not retroactivity is appropriate. I believe that 2 of those factors have important application here. The first question that the court asks is whether this is a case of first impression. Clearly, the answer is yes here. When Mr. Baldwin was arrested in 2013, there was no such thing as a constitutional tort in Iowa. That was also true when he filed his suit in 2015. And I would suggest that the fact that Judge Bennett has certified 7 questions in this case alone is a good indication that we're dealing with a matter of first impression.
Can I ask this question?
Certainly.
In Baldwin, the first time it came up, for some reason, we focused on immunity of an employee when an employee wasn't even a party to the case. So maybe we gave an advisory opinion, but we never focused on the liability of the municipality. And if you look at Iowa common law, before the enactment of the Municipal Tort Claim Act, cities were absolutely immune for government functions, and one of the government functions were policing. If you look at and employees were liable. The employee himself, the police officer, could have been liable, but the municipality was not liable. But for non-proprietary functions, for example, if a statute said the city of Estherville had to keep the streets free of ice, I mean, I'm making that up, there's no such statute, but free of ice, and they didn't keep it free of ice, the city could be sued. And under the proprietary thing, even if the employee exercised all due care or had some defense to it, the city didn't. So if we look at the historical common law, why are we, just because we said an employee has immunity, why does it go to the city?
If I can preface my answer with a comment about the question that was asked in Baldwin 1, it's because I suggested a wrong question to Judge Bennett, not recognizing that we were dealing with a circumstance where only the city was
We have to
party.
live with that, and that's the law.
Okay.
But we have to figure out why it goes to the employer. If you look at historically, under Iowa law, when the city was liable, there was no if the immunity applied to the employee, it never was given to the city.
I think there are two answers to the question. First, as the court observed in the first series of arguments this morning, we now have a statute, the Municipal Tort Claims Act, that provides for that very immunity. But second, if we ignore that and look to the case of Hook versus Trevino, there the issue was whether the immunity that was available to a volunteer should inure to the benefit of the state in an action against the state. And this court said no, because the purpose of the statutory immunity that was available to the volunteer was to encourage people to do that kind of volunteer work and had no impact on the state. I would suggest to you that in this case, where we're talking about the qualified immunity, the due care immunity that was born out of Baldwin 1, that the purpose for that immunity in protecting the individual defendants is identical to the purpose in applying it to the city. One purpose of qualified immunity is to shield governmental officials from the consequences of exercising their judgment. That purpose applies with equal force to the city.
Well, but there's a critique of that, at least in the literature, as you probably know, and that runs something like this. It says, well, when you have an individual police officer who's looking at a judgment that's going to affect daily activities of an officer, it's going to deter, and so forth and so on. But as to cities, the commentary suggests, well, that's a different animal. The city is the supervisor. The city gets to train officers. That's exactly who ought to pay. And that the city won't be deterred by judgments in the same way that an individual would. And therefore, the cities are different for immunity purposes than individual police officers, let's say. I'm summarizing what's out there, and I want to give you an opportunity to respond.
I understand, and I have two responses. One, I think that's the reason for Monell liability, and frankly, Monell liability developed under federal law. And frankly, I think that should be the standard done under Iowa law.
Get that at all. I don't understand why you're advocating for Manel, because the police chief was involved in the decision here to arrest Mr. Baldwin. He's the top decision maker, so under Manel, aren't you on the hook?
Yes, because he would be a policymaker, but
Right, so I don't know where that, I mean, again, I thought we decided this in Baldwin. The question was, can a defendant raise the defense of qualified immunity? And we said, yes, there's an all due care defense. And that's what Judge Bennett said, right?
yes, it is, and I agree with that. But my sense is that that view of the holding in Baldwin is not unanimous on this court.
Let me ask a question. What about the State Tort Claim Act? It does give this immunity, due care to a municipality. Is that the end of the story and no punitive damages and no attorney fees? Because this was brought under 670?
That's my argument. The short answer to that question is yes. I think the legislature has.
But could the legislature declare absolute immunities in a statute and thereby eliminate Godfrey claims altogether?
I don't think so.
So there's some notion that the legislative structure has to provide, I think, to use Godfrey's term, some reasonable avenue of redress, right?
Yes, as I recall a footnote from the court's Baldwin decision, the court has some input into the manner in which these cases proceed.
And slide into the punitive damage discussion that I had before, and as you know, Justice, there was a concurring opinion that said, well, punitive damages might be necessary, depending on the facts and circumstances. And in Godfrey, the notion was, well, this was primarily an economic claim. I mean, he'd been fired and he lost a job and he was trying to get, money for or compensation. But when personal security was involved, that might be different. So I want you to address kind of the punitive damages issue, and the basic argument would be where someone is actually seized and you have personal security at issue, punitive damages is required in order for a statutory remedy to be adequate?
I think it's important to look at that question in the context of this case. We don't yet know what the standard might be for punitive damages if they're going to be available, but it's likely to include some component of recklessness in some way, and that's going to be a fact-based determination. And the thing that seems to be lost here is the facts. The officers are presented with a video. From that video, they're able to identify the operator of the ATV. They then look at the state statute to determine whether or not what they see in the video is a violation of that statute. They conclude that it appears to them that the state statute was violated. They then discuss the matter with their supervisors, who confirm their impression of what they see. And then they screw up because they think that there is an identical city ordinance that says the same thing the state ordinance says, an ordinance or a statute that they believe has been violated. I don't believe there are any circumstances under which those facts generate a claim for punitive damages against the officers, let alone against the city. And I have used my time. I've agreed to make the balance available to the state. Thank you all.
Mr. Phillips, thank you as well. Mr. Thompson.
First, let me thank the court for the unusual opportunity to address the court as a friend of court, and to counsel and City of Estherville for yielding some time. We have filed a brief. I'm not going to re-argue the brief. If you have questions, I'm happy to answer it. What I'd like to do, I'd plan to do, is focus briefly with my time on a practical question about the nature of this cause of action and how that informs the analysis for the questions that you've been asked to answer here by Judge Bennett. But I want to go back to something Justice Mansfield raised, is that this is indeed unusual. And we've got, 7 certified questions in one case. A number of them look like an attempt to get you to rule on summary judgment. And at least one of them, the first question, looks like at least one part of the court believes is a repeat question and part of the court doesn't. There are certainly legal issues here that could and I think probably should be answered. I would argue that the court probably should defer on the weighing the evidence part of this referral. But the nature of the cause of action here, I think, is real important. One of the things that arises in the context of Baldwin 1 and
And Baldwin was decided again, that would against a state official, correct? It
Say
was
that again?
against Governor Bjornstad and
Godfrey,
Godfrey was a state official.
correct?
The State Tort Claims Act does not incorporate constitutional torts.
Correct.
By definition. And what's its limitation on punitive damages, if any?
There's a separate statutory limitation on punitive damages.
Yeah, it's not in the Tort Claim Act, though, right? This case was brought under 670,
Correct,
and it incorporates constitutional torts,
indeed.
and it has limitations on punitive damages, attorney fees, and has its own good faith. It's the exact same immunity. It's the same immunity as we decided in Baldwin.
Due care, correct.
So why wouldn't that apply?
I think
and
there's
why-
I'm
why-
sorry.
I guess the argument is, can the legislature do that?
Well, I think, so there's two pieces. I think this case indeed is not really a Godfrey claim, that it's probably a 670 claim is what he filed. But that's a separate question, and I think that's the position of defense counsel in this case. Justice Appel asked the question about whether the legislature can just wipe out the Godfrey claim, and I don't think, when I read the whole court's opinion, whether in Godfrey or Baldwin, even Justice Mansfield's decision in Baldwin 1, I don't think this court believes that a constitutional claim can just be wiped off. I think reasonable procedural adjustments. I think the trick here, and this is back to the nature of the claim, in your decision, Justice Appel, you characterize these claims as Bivens claims, right? And so if we talk about the relationship with the Tort Claims Act. As much as I'd like to drive this whole thing through the Iowa Tort Claims Act, I think you've both said we can't do that. The Carlson case, post-Bivens, looked at the Federal Tort Claims Act and decided that Bivens' claims should lie because it was an inadequate remedy, and I think that was something you dealt with in the Godfrey decision. Having said that, I think the fact that this court declared this a Bivens action is important here, and I think that the briefing in this matter, frankly, the briefing in Baldwin 1, reflects kind of a mix and mash. I think Justice Wiggins, a while ago, you were talking in the first case, Maggie said, well, this isn't a 1983 case. Well, it's not, right? A Godfrey claim is not a 1983 claim. You said it's like a Bivens claim. And so if we're going to talk about this discussion about punitive damages, about fees, about qualified immunity, give us a place to go. And I think the Bivens line of cases is a place to go. I think, I agree with you, Justice Mansfield, that Monell is kind of a non sequitur here because that's a statutory case, it's a 1983, but under the Bivens analysis, City of Estherville is not a proper party here. Bivens cases are brought about against individuals acting.
The problem is, we said in Bivens it could be brought against individuals and against the state.
Where?
Whereas Bivens can only be brought against the individuals.
If you were, and this is where I just, one of the things that the ALJ or the Association for Justice brief said that I agree with is we need a concise, consistent framework to deal with these things. And I think when you read Godfrey and you read Baldwin, to some degree, there's people talking past each other about whether we're talking about individual liability or entity liability for the state or for the municipality, which is where Monell comes in. I mean, if indeed it's Monell, then it can't be respondeat superior. There's no qualified immunity. And
I mean, Monell to me is an interpretation of specific language in Section 1983.
I agree.
I don't see it has any applicability to what we're doing here. I agree with you, this is a Bivens action. It's not a state analogy to 1983.
right.
All right, that being the case, I don't see why there should be any different, if you're suing an individual for acts committed in the official capacity where there would be respondeat superior, why not one and the same standard for whether you can get punitive damages, whether you can get qualified immunity, whether you can get absolute immunity? Doesn't that make sense?
It does, and you get to decide because this is your cause of action. But Bivens was a unique animal. There are no Bivens cases against the federal government. They were all against individual actors for a reason, sovereign immunity. And so 1983 became a statutory fix for that. Then we end up with individual capacity suits as a legal fiction because of another sovereign immunity problem. But all that jurisprudence gets complicated in all these briefs about punitive damages, for example. You talk about the Carlson case, which
properly understood, if I understand what you're saying, is if we think Godfrey is a Bivens equivalent, the state would have the ability to immunize itself as an entity and its municipalities as an entity from Godfrey claims because they're really not even proper parties.
Correct. But I think that in the capacity issues, and the reason, and I'm over time already, but if I could just point out kind of a factual reality. In the 2 years since the Godfrey decision, we've got numerous cases, Doug's got numerous cases, and we have cases where they have sued the state, they have sued state employees in multiple different capacities, DHS, child care workers, parole officers, corrections officers. In the same cases, they sue those people individually. We've got cases against contractors for the states, and all of that in the context of a complicated defense and indemnity obligation that we have that you even alluded to in Godfrey, that the question of the impact upon individual officers could be solved by indemnity. The clarity on what kind of claim this is will help answer the first question, which is there a claim at all against the city of Estherville? It helps answer the question about qualified immunity, because those are all based on common law immunities that predated these statutory frameworks and that were to individual officials, like you talked about this morning in Venkis. It informs the question of punitive damages, because the cost allocation, the discussion about retribution and deterrence is different if you read Carlson. So, I mean, I know I'm not here, I'm trying to not advocate a particular position other than to say that the difficult questions that Judge Bennett has certified, that we're facing every day, the beginning of the path to solution is to, whatever you do in this case, is to be clear about what the Godfrey claim is, because that then, and who's the proper party, and in what capacity, because only from that do we avoid the problem that Baldwin 1 raises, which part of the court believes you answered question 1, part of the court doesn't. I mean, we actually filed an amicus in Baldwin 1 saying, be careful, don't answer this question, and for this reason, because kind of where the rubber hits the road, we're seeing these multiple capacity lawsuits, and we've got to figure out how to apply this. So we appreciate all the hard work. These are difficult cases. Urge you to answer the legal questions, but answer them carefully. Thank you.
Mr. Thompson, thank you as well. Ms. Bjornstad, you may present your rebuttal.
If I can, I'd like to go back to a few things on section 670.4. The language of 670.4 in this case is pretty important to look at. What it does is if the officer uses due care in the execution of a statute, well, then maybe you got a defense. In this case, though, the officers are off on some ordinance that doesn't exist.
Yeah, but the state statute is when you can arrest with probable cause, and you get a warrant, arrest warrant under the state statutes. So they were using those state statutes to get those warrants and to make the decision to arrest on a mistaken city ordinance. But so they were executing the state ordinances. I mean, you just can't arrest somebody without authority to arrest them.
I guess I'd argue part and parcel of that would be you've got to start somewhere. I mean, you've got to have a statute to start with, an ordinance to start with, and they didn't. So any action that they took then under statutes that allow for
The argument
warrants.
is they didn't exercise due care when they made the arrest because there was no probable cause to make their arrest under the statute.
Right, I agree that there's no probable cause. You're
Said that was the argument. I didn't agree with you.
okay. That brings me to another thing, actually, and that's that this reasonable, unreasonableness concept, alternative probable cause, that sort of thing. It seems like it's real easy to get back on that hamster wheel all the time, and could they have gotten a warrant based on something else? Professor Jeffries, I thought, dealt with that really effectively in saying that when a statute, or I'm sorry, a constitutional provision like Article 1, Section 8 defines things in general terms, that it ought to merge. You ought to merge into the analysis of whether there was a constitutional violation. To a degree, and again, really sparked me this morning, to a degree, 670.4 is a little like that, where it merges a bit. You can't look at this and see, did they use all due care without figuring out, did they violate the Constitution? Because if they
Can I ask you a separate question about the 670.4 question, and maybe you can clarify this issue a little bit for me? The exemptions in 670.4, as I understand it, are really exemptions from the waiver of sovereign immunity, right? Isn't that what 670.4 is dealing with? Or 670, sorry, is dealing generally
yes.
with sovereign immunity issues.
Yes.
And those exemptions are specific exemptions from the waiver of sovereign immunity, right?
Yes.
The immunities we're talking about here, to the extent they're applicable, and I understand there's some substantive concerns with the claim, these are substantive immunities relating to the nature of the claim that are wholly separate than the sovereign immunity issues that are dealt with in 670 and 670.4, even though we're using some of the same language. They address entirely separate issues. Is
Well,
that right?
I think 670 has, to the degree there's a distinction, more to do with municipal immunity and not necessarily sovereign immunity. Those defenses that are in there, I think, are great for the claim where it's the icy street. But when it comes to a constitutional claim like this one, that's where I think the legislature shouldn't, by majority will.
So let me give you an example. Let's say that in a case, a municipal defendant or an employee of a municipality fails to prove the qualified immunity that we're talking about, all due care, et cetera. As I understand it, that's only the first question. In 670, the state can make a determination as to whether or not the state as a sovereign should still be liable for that cause of action. Right? Two separate questions.
I'm familiar with that in Chapter 669, but not in 670.
Sorry, the legislature can make a determination whether or not municipalities should be liable for a particular claim, regardless of the substantive standard on the other qualified immunity question, right?
My time is up. May I answer? I think the difference is in the intent of Chapter 669 and 670. The intent was to expand liability because there were people slipping on the sidewalk that couldn't, if it happened in front of their neighbor's house, they would get compensated. If it happened in front of the courthouse, they would not. And so the intent was to expand liability. When you're dealing with constitutional rights in particular, I don't think that those defenses in Chapter 670 or 669 for that matter can be used to curtail a God-free action or curtail the enforcement of people's constitutional rights. And I'm, again, way over, and I apologize. But thank you very
Ms. Bjornstad, thank you. Mr. Phillips and Mr. Thompson, thank you again. The case of Baldwin versus the City of Estherville is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.